I like cases that are changing our perception of reality. One of these kind of cases is obviously Micula versus Romania. This case is interesting because it is exactly the case where the international arbitration awards a compensation of 178 million euro for the breaches of the investors' rights by the European Commission. This is exciting, this is very interesting. So the story starts when the Romanian government decides to create a tax paradise in its poorest regions, by analogy with the city of London. You know, the city of London is one of the greatest tax paradises on the planet. They have, if you correspond to certain criteria, you pay 0% tax in the city of London. So the Romanian government decides to create a special tax regime in the UNCITRAL region. The investors are liberated from the profit tax and the import duty. And the Micula brothers are the investors who decide to profit, who decide to establish themselves in this Romanian region in order to, build business and pay 0% tax. However, several months after that, the European Union reacts with a common position requiring the Romanian government to repeal its policy because providing tax advantages for a particular region distorts competition in the European Union, provides advantages only to the enterprises established in that region. I don't fully understand this logic because first of all we have the city of London where we have 0% tax, and then we have the rights of the member states itself to declare all its territory a tax haven, to reduce several taxes, for instance, to zero. This is a possibility, and some countries, at least within the European economic space, use this opportunity. I think there are white Europeans and then there are darker Europeans, for instance, Romanians. So for Romania, it is prohibited by the common position of the European Union and then by other statements of the European Commission. So what the Micula brothers do, they appeal to the ICSID tribunal. They have the right to address their question to the ICSID tribunal because they have Swedish nationality. They are ethnic Romanians, but they have Swedish nationality, and Sweden and Romania have a bilateral investment treaty that establishes that investors have the right to fair and equitable treatment. And what the ICSID arbitration decides, the ICSID arbitration makes a decision that the Romanian government promised the investors to apply the tax regime, the zero tax regime, for 10 years. The investors started the investment. Then, after this, obviously, the Romanian government has the right to repeal its policy upon the requirement of the European Commission. However, the guys have already invested money. So it means that you have to compensate them their losses. And their losses are 178 million euro. This is wonderful. This, in fact, is a fine for executing the policy of the European Commission. Well, obviously, the Romanian government lodges an application for annulment with the ICSID ad hoc committee. So the Micula brothers have got an award from the arbitration tribunal, and they go to the Romanian courts to get it executed. And a very interesting thing happens before the Bucharest tribunal. I wouldn't expect this kind of behavior from the first instance tribunal in Romania. And this is wonderful. This is wonderful for three reasons. First of all, the Bucharest tribunal refuses to stay the execution of the award because the ICSID ad hoc committee has refused to stay its execution. This is surprising. This is absolutely wonderful. And then the second point, the European Commission addresses the Bucharest Tribunal and asks the Bucharest Tribunal to make a preliminary reference to the European Court of Justice. In other words, they ask the Bucharest Tribunal to transfer this case to the level of the European Court of Justice, and then the European Court of Justice, obviously, it will follow the line of the European Commission. And the wonderful thing is that the Bucharest Tribunal denies the motion filed by the European Commission. This is exciting. And the third thing is that the Bucharest Tribunal dismisses the main action in the proceedings. It says that, you have to execute the award despite of the fact that there is a slight contradiction between the European law and the international arbitration. So obviously this judgment is appealed, and then the Bucharest Court of Appeals nonetheless suspends the execution. However, the refusal of the Bucharest Tribunal to accept the position of the European Commission allows the Micula brothers to arrest over 10 million euro from the bank account of the government of Romania. Then the European Commission comes with its own decision. Its own decision is interesting from two perspectives. It presents the position of the Romanian government, and it presents the position of the European Commission itself. So the position of the Romanian government is amazing. First of all, the Romanian government states that the Romanian constitution prohibits influencing Romanian judges. This is a very strong statement because it says that, first of all, the Romanian constitution has superiority over the European law, and second, it says that the European Commission wants to influence judges, wants to breach their right to independence. This is a wonderful statement. This is very funny. This is a pleasure to observe the discussion. And then the next argument of the government of Romania is that the award shall be executed until the decision of the ICSID ad hoc committee. In other words, the Romanian government says that it is up to the ICSID to decide whether we shall execute the award, not up to the European Court of Justice. This is a rebellion. This is a rebellion. This is why I think that this is so funny. Then the European Commission itself makes two statements in the decision. First of all, it declares that all the intra-BATs, intra-EU BATs are invalid because they contradict the European competition law. This is very interesting. I think that this is a very radical statement because, you know, the European Commission might have a more moderate approach. It might say that the BATs are invalid, you know, bilateral investment treaties are invalid only to the extent where they contradict the European law. But no, the European Commission makes a general statement that all the bilateral investment treaties are invalid when they are concluded between member states. Well, this approach does not give the opponents a possibility to exit the discussion without losing honor. This is why it is quite obvious that the ICSID would never accept this kind of decision. This is something that made the position of the European Commission itself before the ad hoc committee weaker. And then the next statement of the European Commission is a bit funny. They say that the award is a new state aid incompatible with the competition law because it provides a selective advantage to the Micula brothers. In other words, the European Commission says that among all the investors in the Nocet region of Romania, only the Micula brothers get the award, and therefore it shall not be executed. So this is very interesting because, you know, we had the same in the years of segregation in America, for instance. We had buses for black people and other buses for the white people. And then the blacks were punished for using the buses for the white people. And now let's imagine one black goes to the tribunal and gets compensation for this kind of discrimination. Let's say that the court awards the black, a particular one black who has complained, a compensation for this discrimination, for unfair and unequitable treatment. And then the American authorities reply that we will not execute this compensation, we will not pay the damages to the black guy because the tribunal has ordered to pay the compensation only to this single black and not to millions of them. This is absolutely the same. So the Commission says that the award of 178 million euro may not be paid to the Micula brothers because it is not paid to other investors in the region. I find this funny. Well, Micula brothers appeal from this decision. They go to the European Union General Court, which is the first instance in Luxembourg, and then the ICSID ad hoc committee comes with its own decision. And its own decision says clearly that the award is valid, that the award shall be executed, and all the arguments of the European Commission are dismissed. The ad hoc committee says that the arbitration tribunal has applied the European law to the extent that was necessary. The tribunal has decided that there is no conflict between the bilateral investment treaty between Romania and Sweden and the Europe Treaty between Romania and the European Union. There is no conflict. The tribunal makes a reference to the Vienna Convention on the Law of the Treaties, and it follows from the Vienna Convention that when two governments have signed two treaties, it shall be presumed that both governments were in full understanding of their obligations, and they signed those treaties so that there would be no conflict between the treaties. In other words, the explanation of the arbitration is that yes, the Europe Treaty might require to repeal the tax policy. However, the BAT Treaty says that yes, you have this right, but then you have created legitimate expectations for the investors, and you have breached what you have promised, and therefore you have to pay the damages, you have to pay the compensation. This is the logic of the arbitration. This is completely contrary to the European Commission, because the European Commission insists on the incompatibility of the two treaties, and the European Commission seeks to convince the European Court of Justice or the General Court of the European Union that the BATs have to be declared simply invalid. That simply there is a superiority of the European law over all possible international law. This is a very radical approach. The Micula brothers also tried to execute the award in the United States and in the United Kingdom. You know, they seek to arrest the bank accounts of the government of Romania. The latest development is the order of the High Court of Justice of the United Kingdom. They decided to stay the execution and wait for the outcome from Luxembourg, from the General Court of the European Union, and possibly from the European Court of Justice. Now, at this point, my prediction is that the Micula brothers could benefit from the fact that the United Kingdom will leave the European Union, but they will lose their case in Luxembourg. You know, we have already a stable case law of the European Court of Justice. On 2 occasions, the European Court of Justice has refused to recognize any other international tribunal as having higher power than the European Court of Justice itself. So let's take a look, for instance, at the European Court of Human Rights case, or at the case of the European and Community Patent Court. In both cases, a mere possibility of establishing a court superior over the European Court of Justice was rejected by the European Court of Justice. So in the case on the European Court of Human Rights, there was an attempt of the European politicians to put the jurisprudence of the European Court of Justice in compliance with the European Court of Human Rights, because you know there are conflicts. You know, on many occasions it might be argued that the European Union breaches the human rights. What happens when human rights are breached by the European Commission? A person should have the right of appeal to the European Court of Human Rights. But the European Court of Justice has prohibited this. They have prohibited the European Union to sign the European Convention of Human Rights because, you know, it would in fact establish a higher jurisprudence of the European Court of Human Rights. So the European governments had to sign the Lisbon Treaty precisely in order to create a possibility for the European Union to sign the European Convention of Human Rights. But this is not done until the present. And then the second case was on the possibility of establishing European and Community Patent Court. The European Court of Justice has explained that the European and Community Patent Court would give much more power to this new court in the domain of patents than to the European Court of Justice. And therefore, this kind of court is prohibited So what we have already is that the ICSID tribunal has declared itself higher. In fact, well, this is the practical implication. They do not use this kind of wording, but I translate it into normal language, that they have a higher power than the European Court of Justice because they can punish member states of the European Union for the actions of the European Commission and for execution of the judgments of the European Court of Justice. So therefore, my prediction is that the Micula brothers will lose their case in Luxembourg. But I am not sure that the courts of the member states will follow the line of Luxembourg.